everyone. Thank you again for joining us for another exciting TPN Schools webinar. We're very, very excited to have you here. Today's webinar is focusing on compliance and what we need to ensure so that our schools stay up to date with legislation specifically aimed at safeguarding our schools, our teachers, and most importantly, our children. My name is Ashley Laurent, Legal Counsel here at TPN. I'm very, very excited to introduce our guests. On my left, we have Ms. Ntombizodwa Majila, the National Registrar of the National Register of Sexual Offences, the NRSO. And on my far left, Mr. Marius Buerta of MBK Consultants, a legal advisor and specialist in discipline and school management systems as well as labour relations. Thank you both for joining us. And you may not see him, but you will definitely hear him towards the end. Head of Legal, Greg Mason, he is facilitating and he will definitely provide the questions when they come. Just a few housekeeping rules before we begin. Please ensure that you are logged into YouTube to participate in the chat. If you are having trouble, please contact our help desk team. They'll be able to assist. There will be a 15-minute Q&A session at the end of our discussion. So we would love to hear from you. Please pose your questions. If for whatever reason we do miss your question, you can contact our help desk team, helpdesk@tpn.co.za, or contact us on 0861 876 000. If your question is a legal one, you can also contact legal@tpn.co.za. There will be we will submit a feedback form during our Q&A, so please be sure to complete our feedback form. We would love to hear from you, any recommendations, your views. We would love to hear from you. And then if we are looking a bit blurry, there is a cog on the bottom right-hand corner of the YouTube screen. Please select 720p or higher so that you're able to see us and everything looks clear as day. Guys, I'm going to jump right in. So today's topic is an important one. TPN recently confirmed that 3.6% of teachers have a criminal record, and more than 2/3 of those teachers or staff members are not declaring it upon request. And I think you would agree that that is a shocking statistic, but one that schools can definitely check and address through the correct vetting procedures as they go. And Ntombizodwa, I'm going to start with you. Could you please provide us with an insight into the role and function of the National Register of Sexual Offenders?
Thanks, Ashley. The National Register for Sex Offenders, simply put, is a database which is actually managed by the Department of Justice and Constitutional Development. However, it is implemented in terms of the Act, which is the Criminal Law, Sexual Offences and Related Matters Amendment Act. It is an act which was passed in 2007. However, the implementation of same happened on the 30th of June 2009. And now the primary objective of the National Register for Sex Offenders is to record the details or the details, yes, of everyone that has been convicted of committing any sexual offense against a child or someone who has mental disabilities. However, recently we've got an amendment that actually have added or expanded who then gets protected in terms of the Act. We're now talking about vulnerable persons, wherein the scope has been extended to include not only children and persons with mental disabilities. However, it is an older person who is above the age of 60 years and older, or is anyone with sensory disability, with mental disability, with physical disability. in that list. So anyone who is found guilty of committing any sexual offense against those categories of persons, then your name gets included in the National Register for Sex Offenders. Now the objective is, when your name appears in the National Register for Sex Offenders, you may not work with vulnerable persons in that space or exercise any supervisory position over them. You may not also be allowed to adopt or foster any child or apply for any kingship caregiving in that space. When your name is not there, you are actually precluded from doing that or working with them.
Okay. And just so our viewers understand, there are in fact two registers which schools vet against, namely the Sexual Offences Register and the Child Protection Register. Can you please explain these two registers to our viewers, and what exactly are the differences between these two registers, and is it compulsory that they do the checks against both registers?
Yes, of course. It is compulsory for anyone that works with children or vulnerable persons to be vetted against the two registers. When you're looking into those registers, you will agree that each one mirrors the other in one way or the other. But when you look closely now, the National Register for Sex Offenders, as I have explained, is only focused on sexual offenses and when you are convicted of such.
Yes.
And the National Child Protection Register is managed by the Department of Social Development and looks into all forms of abuse, which includes sexual offenses, murder, neglect, but that has to be perpetuated only against a child. And even when you are found unsuitable to work with children, your name will appear in the National Child Protection Register. But the National Register for Sex Offenders only looks into sexual offenses convictions. And it is essential that anyone that works with children or accesses them in any way, manner, or form be vetted against the two registers, because they serve a different purpose or a different mandate. Even if that mandate we can all agree to say, but children in both registers are involved. But when you look into sexual offenses, we have now extended the scope to include not only children, but other vulnerable groups.
And as you said, your elderly individuals and those...
And young women under the age of 25 who are attending tertiary education, who are living in dormitories or hostels, as we used to call them, or who are doing vocational training, or who actually reside in those spaces.
Yes. Marius, I'm going to bring you in here. As Ntombi has touched on, we have multiple pieces of legislation regulating vetting and criminal checks and clearance certificates for our teachers, ground staff, administrative staff. So we have the Criminal Law, Sexual Offences and Related Matters Amendment Act, as well as the Children's Act. Could you provide us with an insight in terms of legislation, what is required of staff and educators for vetting and criminal checks?
Thank you, Ashley. Yes, I think we've got there's two ways in approaching this, because there are two employers on all school grounds.
Yes.
On the majority of Quintile 4 and 5 schools. Quintile 1, 2 and 3 won't have SGB staff members unless they are sponsored by an outside company and supplied to the school.
Yes.
However, the rules are the same for everybody. They have to undergo the vetting process, and if they are convicted in any of these legislatures forums that was mentioned here, then they cannot become an educator. Because if you want to define it to the SGBs, SGB employees in terms of Section 20 of the Act, the SGB has the right to create PS and CS and general assistance positions. That's basically the three categories.
Yes, yes.
However, by appointing them, they've got to see that they fulfill all legal requirements, and they must be employed legally in terms of the Labour Relations Act determinations, and contracts must be in place, everything. But the vetting process must be done for all of them.
Yes.
And very recently, in the High Court in Western Cape, a school, the principal and the MEC of Education was found guilty because they employed somebody which did not complete the vetting process and did not basically successfully completed the vetting. So the name, he was now convicted, his name was nowhere appearing. They didn't check that, and that guy got involved into some sexual offence with children.
Yes.
And then the school principal and the MEC was found guilty in the High Court in the Western Cape.
And that's exactly it, right? I think schools, your public or your private or independent schools need to understand that the buck stops with the principal as well. It lies with the principal that they need to ensure that their staff are compliant.
I just want to add to that.
Yes.
I don't think we've got to only look at the public and independent schools, because we also look at aftercare centres,
Yes, of course.
and
your
nursery
creches,
schools
100%,
and preschools,
100%.
because the rules are exactly the same there, and I think there's a lack of education there, because I think a lot of people get employed there by not following this process due to the costs involved, and we can later talk about that.
And I think, so TPN also focuses not only on your major schools, public and private independent schools, but also creches as well, kindergartens, because they also, dealing with children, need to ensure that they are compliant. So Marius, what would you say is best practice for schools in respect of conducting the necessary checks on staff? And when I say this, I'd like to also maybe discuss, and Ntombi, please feel free to jump in as well here. How do schools approach checks with your new staff versus your current staff? So what is the position in that respect, and what should be deemed best practice?
In the provincial department appointments, meaning that is state employee, the educators in school, the responsibility therefore lies with the education department of the province. They do have everything in place, because the process in terms of the Employment of Educators Act and the PAM document stipulate a specific procedure that is well thought, and it's applied, and it's good. The fact is, part of that is you will go through your shortlisting processes after receiving the applications. The department receives that, and then when you take your shortlisting people and you invite them to the interviews, you ask them to bring all of these proofs that they have not been convicted, must be brought with them to the employer. Otherwise, the employer cannot, if they recommend it for employment, they cannot be appointed. With SGB, however, it is a different ballgame, because there is a cost involved. So when SGB positions are advertised, we follow the same process of shortlisting after applications, but then when we invite the people, we say they must bring these clearance certificates with them before they can be considered for appointment. While on the department side, the department fulfills the role and requests these certificates from their side, while the SGB then requires the employee to bring these certificates. But the good practice, or the best practice, is it must be checked by all institutions working with children. It doesn't matter which age or whatever, you have to do that. And in a practical situation, I would say all schools have to develop a procurement policy stipulating exactly what must be done, because there's a lack of that in certain schools, in my practical experience, that they don't have procurement policies in place. And then that leads to loopholes, that they skip things and they don't do it properly.
Of course.
But Tommy can answer regarding the existing and the new staff, because that is a challenge.
Tell me, how would you go about that with the current versus your newer staff?
Essentially, everyone that accesses children, whether in that space as an employee, let's say in this space as a teacher, whether you have been with the school for 40 years, in the coming into effect of the Act, all schools ought to have vetted the existing staff against the register, because Section 45 of the Act provides that any employer that employs an employee that works with children must obtain or ascertain by way of application to the Registrar of the National Register for Sex Offenders for a certificate that actually validates whether or not that person has got a previous sexual offense. So it is essential for an employer to vet the existing ones,
Yes.
because they might have in their previous life a sexual offense.
Yes.
And then if you have a conviction, then you don't have to be working with children. And the ones that are coming in, the potential ones, like Marius has said, you can either, as an employer, when you are looking into a short list or a list of shortlisted candidates, ask them that they must provide a certificate that comes from the registrar that actually ascertains whether or not they don't have a sexual offense conviction against a child.
Yes.
Because the primary objective is to protect the children against any
Anyone.
convicted sex offender.
Yes. So whether staff that's been there for years and
40
years,
years, yes.
your new staff.
Yes.
And
If I can just interject.
yes,
Ashley,
please.
The employee as well, the one that is currently working. Let's say, for example, you have a sexual offense conviction in your previous life as a 14-year, 16-year-old in
Yes.
those years. You've got an obligation to disclose to your employer that I've got a sexual offense conviction, which I got before I could even start thinking of working as a teacher. And then the Act says when your employer sees that you've got that, they have to move you to a place where you cannot access children. Or if they cannot move you, they have to let you go, meaning that they have to dismiss you
Yes.
accordingly. Because no employer must allow any employee that has got a previous sexual offense to access the children.
And Marius, I'm going to bring you in this instance here. It's what should a school do from a school management perspective? They do the relevant checks and they say, oh my goodness, teacher has a previous conviction, sexual conviction. How do they go about dismissing? Because I think that's quite a tough job to actually address that, especially if it's been a teacher who's been there for years and years. Now all of a sudden we see this, oh my goodness, we have to address it. We have an obligation as a school to address it. How should schools address it?
The schools are bound to the Labour Relations Act, which is Schedule 8, the
Yes.
fairness. And they will have to follow a procedure of incapacity because this person is incapacitated. However, incapacitate not through not being able to do the job, not having the knowledge, but not having the right qualifications. And the person will be dismissed and not being able to be appointed
Yes.
for any, because you're going to run a risk in keeping him there. He will have to be dismissed and removed immediately, suspended, whatever it
Yes,
might need to be.
yes.
And then there will have to be a process followed to dismissing. There was actually a court case recently where a person was dismissed. He approached the Labour Court, but the Labour Court upheld that you cannot work there.
Yes.
And the fact that you didn't declare it, right, and you employed it, it's not an excuse. We cannot continue the risk allowing you to work with children. So in terms of Labour Relations Act, yes, they can be dismissed, and there's been examples for them being dismissed due to the fact of having a criminal record in the registers, or even committing something, keeping quiet of it, and then it comes about, and then they've, after checking everybody's validity regarding this, and found that there is a conviction, that the person can and should be dismissed.
Yes.
Yeah.
Okay.
Remember, children's interest always comes first.
Yes, of course. I mean, it's with courts acting as the upper guardian of all children. You know, the children's interests are paramount. Intomi, I'm going to jump back to you here, and Marius, you can also interject here from a labour relations perspective. The definition of employer in terms of when we speak of the National Register of Sex Offenders is very specific. I don't know if you want to elaborate on the definition of employer, because it's very specific to who can conduct these checks. So could you please elaborate on the definition of employer in this respect?
Yes, the employer means any department of state or administration in the national or provincial sphere of government, or any municipality in the local sphere of government, or other functionary or institution when exercising a power or performing a duty in terms of the Constitution, which employs employees in any manner, and during the course of their employment will be placed in a position to work with vulnerable persons. So this could also be any person, organization, institution, club, sports,
Yes.
association or body, which in any case may be or employing employees who in any manner during the course of their employment will be placed in a position of authority, supervision or care of a child, like what I've explained. But it's anyone. And this could very well go down or cascade
Yes.
to even you having employed a gardener who will be accessing your children, or a helper in the house. Anyone that you employ to actually look after the interest of any vulnerable persons, then you become an employer. Not only does it necessarily relate to maybe schools or anyone, but any other person that employs anyone in that space, you then assume a role of employer.
And I'm so glad you read that, because I think a lot of schools may think it's limited to our educators, and that's not the case. We also need to look at our third-party groups. Maybe we have a gym school, sport coaches as well, ground staff as well, that need to go through these checks against both registers.
If I can just butt
Yes,
in there,
please.
if you'd recall, it was a couple of years ago where there was a problem with a security guard
Yes.
having sexual affairs with learners on a school ground. And that was a big blow up, and it actually created the spotlight on this. But a lot of people have the belief that, okay, the security guard is CIRA registered. But if it's even CIRA registered, he's still got to do this.
Exactly.
CIRA registration does not mean automatically that he's exempted from this.
From this, yeah. Exactly, 100%. So, I don't like speaking on consequences, because it's such a broad term, right? Consequences. Outside of a moral and ethical consequence of not complying with this, Ntombi, I don't know if you want to just specify what consequences schools may be facing, and Marius, please also, if you'd like to add in this respect, what schools could be facing if they don't comply here.
Simply put, if you don't comply, it's a criminal offense. Wherein if you are found guilty, it is either you can be given a fine or a prison sentence. As clear-cut as that. So, which means it is a prerogative on every employer to ensure that any employee that will be working with children must be vetted accordingly. Because failure to do that, it's a criminal offense.
And it's not just limited to those that don't conduct the check. It's also limited, it also includes those that conduct the checks, are aware of this teacher has previous conviction, but we don't do anything about it. We just hush hush.
But following on the criminal aspect, that you are fined or whatever, if something went wrong, then there can be civil claims.
Yes, 100%.
Not because of that. So, it's a double barrel. You're going to get in problem because it's a criminal offence if you didn't do it. And who didn't do it? The employer or the person responsible for doing it. On this side, if something happened, there can be civil claims between the employer and the individuals.
Precisely.
It can be.
100%. And then, Marius, you were also mentioning prior to the webinar going the costs, the cost aspect on this. And I don't know if you want to elaborate on what you were stating on the cost aspect with respect to criminal checks and the problem we're facing in that respect.
Yes, thank you. The problem is that you've got, say, 100 educators at a quintile 4 and 5 school, which 75 is employed by government, 25 by the SGB. Now they've been there for 6 or 10 years, whatever, and now we've got to do the checks. So the certification doesn't cost, but the fingerprints at the police stations, they do charge money for that. And that varies from 170 to 270 even, and we don't understand why does this vary. We cannot, because there should be a one price to do this.
Exactly.
And
yes.
that's a problem. And Tommy then also mentioned, but if you are a job application, you're a job seeker, there's also that you can, there's a statement that the government gave out that if you take that with to the police station, it can be for free. They can do it for free. But I think very little people know about that. I think very little people know about that.
Yeah.
But coming back to the problem with the schools, you see quintile 4 and 5 where there's school fees payable, the SGB can budget,
Yes.
and they can build in a 35 or 40 or whatever it might cost and do all the staff at once. The problem, however, is quintile 1, 2 and 3 schools where no school fees are charged. And if they
Yes.
want to vet these educators, where are the money going to come from? They'll have to hand it over to the employer, the Department of Education. But if they also have a SGB, but if the SGB want to be proactive, it's going to be a problem for them to obtain the funds to do that. And I'm very, you know, if we look at schools, there's 24,000 schools in South Africa, of which, say, at least about 2,400 of them are quintile 4 and 5 schools. So the majority are quintile 1 and 2 and 3 schools. So that's a very big problem coming to the government, who will have to carry the cost or have the process. And as Tommy said, you know, we must actually, the ideal would be to check it every 2 years.
Yes.
That's going to be a cost.
Intombi, I don't know if you want to just elaborate a bit more on that from the National Register's office. What is the position in that respect?
On
The costs, yes.
Yeah, from our side, the certificate is free. However, that which comes with the certificate, which are supporting documents, like your fingerprint report, like what Marius has said, that attracts a cost from SAPS, which varies obviously what he has said from 170 and 250 thereabout. But I'm not sure with the educators or from the Department of Education whether or not they could enter into an agreement, because they are government officials, whether or not a consideration can be made, wherein if you are applying to get the certificate, so that if you want to get a fingerprint report, then the fee can be waived. But that is something that they have to actually negotiate and agree on that space,
Yes.
you know,
Yeah.
from the ministry level. And yeah, I think if they can reach that agreement, that can be
Yeah.
done. But from our side, the certificate, we issue it within 10 days of application,
Yes. Yes.
and it is free of charge.
Okay. Thank you for just elaborating on that. Greg, I see you were waving. You have a question from one of our...
Yes, there's one question that's come through just on the relation of costs. So when you have SGB as well as department employees, should an SGB also budget to cover those costs of the government employees, or should they sort of send them to go and do the checks themselves? And I think just from the side of a school, it's important to touch on the school's responsibility again to ensure that the people that they employ are clear. So
Yes, of course.
if the school does have the ability to cover those costs, it's definitely within their interests to avoid employing persons who are convicted.
Yes, 100%. I don't know if you guys want to maybe add a bit on that, but I think it is necessary to budget for that. Marius?
Quintile 4 and 5 schools will be in the position
Yes.
to budget for it, and I would recommend them to do it to limit the risk for your school.
100%. Yeah.
Right, and to act in the interest of the learners in the school. So I'm comfortable that the HGBs in quintile 4 and 5 can budget for that.
Yes.
Quintile 1, 2 and 3 people cannot budget for that unless they get a sponsor or they enter into negotiations as government officials to be able to obtain those fees to be waived.
100%.
And I think that would be the way to go for the quintile 1, 2 and 3 schools.
Great. Okay. Fantastic. And then we were briefly discussing, Ntombi, what should you do if, not necessarily a convicted, but a school has a mere suspicion? You have these close-knit communities where, there's a rumor that so-and-so's may be involved in something. What should a school do if there's a mere suspicion of someone allegedly committing a sexual offence?
That's an interesting question, because the Principal Act, the 2007 Act, only required someone who had knowledge to report such to the police, and it ended there. What is interesting now, we've got a new Amendment Act, which was passed this year in January 2022, which states that if you've got a reasonable suspicion, an inkling or whatsoever, report that to the police, and the police must investigate. So most of the people did not want to report on the basis that you'll be made a witness at the end of the day, and it's time consuming, and they don't have that proof that this actually happened.
Exactly.
You don't need to have proof. And what is interesting also, the Act actually places you in that space wherein you realize, you recognize. And then after doing that, you have to take your reasonable suspicion and report it to the police. If you don't, again, what is interesting, it is a criminal offense, wherein if you're found guilty, there is a fine that is attached to that, as well as a prison sentence, or to both, which a prison sentence can be a period not exceeding 5 years.
Okay.
So the primary objective, like I've said, in emphasis, that it is to protect children against anyone that can be, accessing them in a way which is not comfortable to them, or molesting them sexually whatsoever. So you need to report that to the police, and then the responsibility now is upon the police to investigate that and bring the perpetrator to book.
I think 2 points from my side is, one, what would constitute a reasonable suspicion? And number two, are police aware that, even if it's a mere suspicion, that they need to act on that in respect to the act?
Yes, they are aware.
Yeah.
Yesterday I saw one circular which was actually issued out by their legal services, which was confirming the coming into effect of the Act.
Okay.
And what are the provisions of the new Amendment Act has come up with. So I can comfortably say they are aware, and then they should not, based on your reasonable suspicion, turn you back to say you don't have proof. Give us proof, because the reasonable suspicion is the one that propels you to go and report the case accordingly.
Yes, yeah.
The same reporting duty is also found in Section 110 of the Children's Act.
Of the Children's Act, that's
And where you've got a reporting duty if there's a reasonable suspicion that it happened. And you can report it in terms of the Children's Act to the SAPs or social workers. The problem practical on the ground is limited availability of social workers.
Yes.
That's a big problem. And that there is a lack of understanding in SAPs. And some some police stations are totally up to date, and they work swiftly with these things. But there are others that are not that knowledgeable.
Yes.
So, that is a challenge. However, there's a misperception if we come to educators. They're very, very cautious of reporting it, even if they have a reasonable suspicion, because I think there might be claims against them.
Yes.
However, Section 110 and the Sexual Offences Act said, if you report it, you acted in the best interest of the child. If it comes about that it was not true, they can't file charges or claims against you.
Exactly.
But if you don't do it, you can become accomplice. So you can also be charged. And that's what we have to educate our educators to do, that, and the reporting duty. The problem is sometimes the educators, because they're concerned over children, want to get involved in the action part. That they shouldn't do. They've got a reporting duty, and in the school environment to limit the risk, and try and do whatever they can to limit the risk. But they cannot go after hours, after school, get involved there. That's police and social worker responsibility.
Yeah, I think, Marius, you touch on a very, very important point. almost from a whistleblower perspective, what is the position from the National Registrar's Office in respect of whistleblowers? What protection are they guaranteed if they come forward and say, hey, there is a reasonable suspicion XYZ?
You see, the Act is silent on that, except that it encourages anyone who's got a reasonable suspicion to report, same to the police. And I think once you start reporting that to the police, then the consideration under the whistleblowers will then kick in terms of, now that you are a whistleblower, what is the protection that is going to be afforded to you for blowing a whistle against?
And I think, Marius reached the point that they can't then act because they were acting in the best interests of that child. Yes.
Precisely.
Then I wanted to ask, Marius, what should a school do if it's a pretty straightforward question, but what should a school do if an employee says, I don't want to partake in this, I don't want to do the checks, I don't want to do the checks.
They can't be appointed. They cannot be appointed at all because that's requirement, the prerequisite for appointing the person.
For that,
and then they
100%.
must accept that education is not available for them in all the institutions.
Yes.
And adding to that is that if you're already employed and you don't want checks to be done thereafter, because that's compulsory by law, can be enforced.
Yes.
All right. So if you don't want to do that, then you're actually going to be dismissed. You can be dismissed.
Yes, that's correct.
Okay. And then I think then that brings us to our questions, our Q&A, unless there's something else you guys would like to add from your side. Before we jump to the Q&A, Marius?
If there's a minute available, I just want to look at the POPIA Act regarding
please. That's actually
the
a very
POPIA Act,
important point.
which the sharing of information, confidentiality. The school tends to become the playground or the war ground between parents divorcing, demanding information from the school, it's personal information. And that sometimes leads to certain situations where children are actually becoming the play ball in between, throwing around. That can also fall under this neglect and even misconduct towards learners and, putting them under pressure, crying every day, cannot attend to school. That's one thing. And then POPIA gets in, what information should the school supply to either parent?
Yes.
And court orders get in there. And the schools are not totally geared to that. But the short answer on that would be they've got to look at the court orders and adhere to the court orders. Both parents have access to information. And the other part about POPIA is when therapists work with learners and they deal with very sensitive matters, what must they deal with the rest of the educators? And my belief is they must deal enough information with them to be enable them to do their work.
Yes.
But don't do an overload of information that's not needed for the educators to perform their duties, because that can actually also become an offence.
Yes, of course. So I mean, it's a very, very fine line as to how much information is shared with these teachers, but you still have to provide sufficient enough for them to provide a valuable education to that students. I don't know if you want to maybe add anything on that front, Ntombi, or it's very, it's a very different position to look at, but a very necessary one.
It is necessary. I agree with what Marius is saying. Because you will find people using POPIA not to comply with anything.
Yes.
I think for some has become now a shield that they can use for them not to comply with legislation. But it is essential that parents, you comply with that and not use. And if we look into the best interest of the child as provided for in terms of Section 28 of the Constitution, then we will know that it's not about us, but it is to safeguard the interest of those children.
Okay.
And also Section 11 of the POPIA Act.
Yes, of course.
Pertains to minors, So we have to consider the rights of children and the duties towards them.
Paramount importance.
Yes, 100%. I just thought of one last question as well. Ntombi, from the registrar's perspective, how often should a school conduct these checks?
You see, we've said when we look into cost implications, 2 years is a reasonable time, but in 2 years, in 2 months, in 2 days, after I've issued the certificate, something can happen. Then how do you ensure that those children are protected? But we've said the validity of the certificate, although the Act is silent on that, but the validity of the certificate should be as of the date of issue.
Okay.
So if the school feels, or you've got that reasonable suspicion that probably Ntombi might be having a pending case against her.
Yes.
The reason why we request that you attach a fingerprint report to your application form, it is so that we can see whether or not you've got any pending cases of a sexual offense in nature that you have against you. So as of the date of validity, if you feel that I've applied yesterday, I also want to apply tomorrow, you are welcome to do that.
Very good thing to know. Greg, do we have questions from our viewers?
We do. We have a few. I think, Ashley, you may have read my mind, because the first question was going to be how often should the checks be done, but that has been covered, so we don't need to worry about that now. Thank you so much. So one of the first questions is, when there's an offence on your name, even if it's still a case pending, will this still be picked up through checks? And I think, Ashley, maybe you can address this from TPN's point of view when we go into our checks out at schools, and how quickly things like possible action is noted.
Yeah, so even pending action, I mean, when we conduct our biometric checks, we get those biometric results from AfriSwitch in 24 to 48 hours, and it will state that there's either no illicit activity or illicit activity, and even if there is a pending case, it will still reflect in that sense.
Perfect, thank you. And then the question that we are getting, I would say probably more than any other, is what is the expected turnaround time in order to get a lot of these certificates?
10 days.
10 days turnaround
From
time.
the date when you apply to the time when we respond back to you. As soon as we receive it, in 10 days, we ought to have. Sometimes we can issue it whilst you wait, but most of the time, the Act provides that we need to give it to you in 10 days.
Perfect, thank you. So the next question is that the large majority of teachers and applicants to become teachers are not aware that they should have a police clearance certificate, let alone vetting with the NRSO CPR. There seems to be a major gap in what's expected. I think it's important here that maybe we discussed it during the webinar, but I think we should reinforce it of exactly whose responsibility it is to ensure that clear certificates are received, not just on the applicant.
It is the responsibility of the employer as well as the responsibility of the employee. In this instance, how it works, like what Marius has said, sometimes an employer or a potential employer can ask you as a potential employee, for you, when you are called for an interview, please provide us with the certificate that actually indicates that you are not a sex offender. Or the employer sometimes can take that responsibility, assume that responsibility, and apply on behalf of its employees for a certificate ascertaining whether or not. So it goes both ways.
Perfect, thank you. And I think one here potentially for Marius. So let's say you become aware of a potential existing situation. You have suspicions regarding a teacher. From a sort of labor perspective, how do you deal with a teacher to remove them from their situation where they have access to children?
You will at first immediately suspend that. It's educated to limit your risk of any contact and anything happening with the learners. So at a labour viewpoint, you will suspend the person. It would be a fair suspension. And then the suspension has got to be reasonable. So it can't be for the long term and that. So then you'll have to finish your investigation, get the proof correct. And if the proof is there, then you will move over to a disciplinary hearing. And you'll have to do that in disciplinary hearing, following the prescribed rules whenever it's a person employed by the education department or the SGB, and follow the policies as prescribed, have a disciplinary hearing and dismiss this person.
Perfect, thank you. And then just as a bit of a follow-up to that as well, let's say you become aware of a situation that may have occurred years ago at a previous employer, but the person failed to disclose it on their CV. Who bears the responsibility of following up with the checks to see?
That's a good question.
Yeah, well, the employer would, if there becomes a suspicion, okay, the employee didn't declare it, it depends on your application form. If there's a question in your application form, are you aware of any possible action against you instituted or ever found guilty, and you don't declare it, it's fraud. Then they will dismiss you. They will dismiss you.
Yes.
They will dismiss you immediately for the fraud, not completing that. If that question is, however, not there on certain application forms, it is not there. Then we will have to conduct again an investigation.
Yes.
And if we determine that this person is guilty, we'll have to institute action immediately there. Then.
Thank you. So yeah,
Because to add to that, it is the obligation again, which is why I said it goes both ways. I've got an obligation, if I've got a previous conviction, to disclose that to my employer. And then once the employer ascertains that indeed I've got that, they have to dismiss me or move me elsewhere. If they cannot move me, they have to dismiss me. But like what Marius has said, if you fail to disclose, it's a criminal offense, which means the onus is upon you to disclose accordingly, so that there could be some consideration that is made on your behalf, whether or not to move you to provisioning or to whichever section where you're not going to access the children.
You see, in addition to that,
Yes.
school ground's a very difficult situation. So Schedule 8 says, yeah, I've got to reconsider other positions where I can, where there's no risk for you or no contract. But people on school grounds, everywhere, they have contract with children.
Exactly.
So basically, in a school environment, there is no alternative for that person but up to be dismissed.
Yeah, that's perfect. And I think something to add to the question specifically is the fact that incidents may have taken place under the sort of supervision of a previous employer doesn't take away your responsibility as a current employer to ensure safety in your premises.
For sure.
So yeah, the fact that it may have happened under previous employer doesn't take away your responsibility to ensure that teacher has got proper certificates in place. The next question is regarding specifically the NRSO. How long does it take between someone being convicted of a crime to then appearing onto the register itself? So if from conviction to appearance on the register, what's that sort of timeframe?
It is an immediate effect. Because once the court makes an order convicting a person of a sexual offense, the Act says upon doing that, the court must then explain the consequences of that conviction and it must make an order. The order saying that we are now going to place your name in the National Register for Sex Offenders, and it must explain the effect and the consequences of putting your name in the register. So immediately after that happens, the court clerk in the court, because how we manage our database, it's an integrated case management system which takes into effect the process that happens at court. So when the order is made, and the court clerk must forthwith forward that to the registrar. So it's an immediate action. When the court order is made, then the court clerk must send that information. Then that particular person is placed in the register pending whether or not this person is going to consider making an appeal, pending the finalization of an appeal or a review. But we actually place that immediately when the order is made.
Perfect. Thank you very much. So we only have one more question left, and I think this is probably one that Ashley will be able to answer. But if you are a school that wants to go about the process of carrying out your criminal checks, who do we contact? How do we go about getting and applying for clearance from these registers?
100%. So we can definitely, you can give TPN a call. You can ask to, or you can go through our help desk team. They'll put you through to either Odette or Wendy. You can ask for either Odette or Wendy, and they'll be in touch to organize the necessary checks for your school. I think from a TPN side, the main thing we want to drive home is to ensure that your school is compliant, and going through the TPN process gives you that peace of mind that you will be compliant, you will meet the necessary requirements per legislation. We will make that easy for you. We offer simplicity in that respect when you can focus on providing value to education for all students alike. I just want to ask one more question. Marius and Ntombi, I just want to ask, if it's not necessarily an offence, a sexual offence, but one of fraud, and that comes up, and we see, oh, there's one for fraud. How does it won't be one that the registers will deal with per se, but something that the school might have in place. They might have a zero tolerance policy on that respect. Marius, how does a school deal with another offence that's not necessarily a sexual offence?
The guideline there would be for educators specifically,
yes,
the South African Council for Educators,
yes,
because they do have a list of offences
okay,
that does not allow you to qualify to exercise your duties as an educator anymore. And there's a list of that, so you'll have to compare that with all that. I can't recall all of them at this moment,
okay,
but that's one thing, because if you don't get a SAE certificate, you cannot be educated.
yes, of course.
However, on the school grounds, there's a lot of circulars and general notices relating to somebody working, for instance, in the financial office of a school.
Yes, a person,
Cannot be
whatever,
guilty of fraud or any money laundering, anything like that, and
yes,
even being blacklisted and backed, with bad debts and all of that.
yes.
So, there is certain qualifications. The SGB, however, has got its own prerogative when it draws up the policy regarding SGB staff, regarding that. But the one that I've just mentioned is a department circular stating that.
Okay. Yeah, and I think that's important to note, and it'll obviously depend on one's employment contracts and the policies of that school, whether to take disciplinary action in that respect. But then I think that is it. Thank you very, very much for joining us. If you have any questions, you're welcome to contact our help desk team, helpdesk@tpn.co.za. If you have any legal questions, you can contact legal@tpn.co.za. Give us a call if you'd like to organize an appointment. Please definitely give us a call. Ask to speak to Wendy or Odette. They'll be more than happy to assist in that regard. But thank you very, very much for joining us. We look forward to all our future webinars